I'll tell you what, the New York Times
really do not want to be deposed.
Viva Frei, Montreal litigator turned YouTuber, and this is Winnie the Westie, who's going onto the chair now, and there has been an update in the Project Veritas versus the New York Times defamation lawsuit. The 30,000-foot overview for those of you who may have been living under a judicial rock. Project Veritas James O'Keefe is suing the New York Times for defamation for what some might call a hit piece that the New York Times ran on Project Veritas when Project Veritas released their expose of a report about people doing things that might be questionable in the context of an election. Project Veritas released their expose at roughly the same time the New York Times had released their bombshell expose about Trump allegedly not paying any federal tax for 10 years. Apparently, the New York Times was a little miffed that Project Veritas was getting a little more attention than the New York Times itself, or at least that is the running theory. So the New York Times, in conjunction with the EIP, which is the Elections Integrity Project, coordinated their efforts to run a piece that alleged that the Project Veritas expose itself was coordinated disinformation. The New York Times alleged that the Project Veritas expose was coordinated disinformation, that the laws they alleged were broken in their expose were in fact not broken because they were in fact allegedly not laws. That turned out to be factually incorrect, and other news outlets relied on the New York Times piece in order to claim that the Project Veritas expose
was itself bunk.
Well, Project Veritas and James O'Keefe did not take too kindly to the New York Times accusations, and they sued the New York Times for defamation, alleging that the New York Times defamed Project Veritas. As could be expected, the New York Times filed a motion to dismiss in which they raised a number of arguments. First and foremost was that they were not making statements of fact in the impugned articles, they were making statements of opinion. In other words, they were invoking the Rachel Maddow defense. Well, the New York Times motion to dismiss was itself dismissed, and the New York Times proceeded to file a defense in the lawsuit in which they made certain admissions which utterly contradicted some of the arguments they raised in their motion to dismiss. In their defense, the New York Times admitted that the impugned articles were not opinion pieces, that the impugned journalists were not writing opinion pieces, and that they were in fact in the fact section of the New York Times. Setting aside the fact that some of the arguments they now raised in their defense absolutely contradict some of the arguments they raised in their motion to dismiss, they made a number of very substantial and material admissions, and I did a video breaking that down. If you haven't seen that video, go check it out. I'll put it in the pinned comment or something. Well, now it would seem that after having filed a failed motion to dismiss, after having filed their defense, they filed a motion for stay of proceedings, for stay of the depositions that were to be held in the context of this file, on the basis that proceeding while they appeal the dismissal of their motion to dismiss will cause them irreparable harm. Supreme Court of the State of New York, County of Westchester, Compliance Part. Project Veritas plaintiff against the New York Times Company, Maggie Astor, Tiffany Shue, and John Doe's 1 through 5 defendants. Defendants' memorandum of law in support of order to show cause for stay of discovery pending appeal pursuant to CPLR 2201 and 5519C, and interim stay during briefing of motion. Non-legalese translation, this is the memorandum, sort of the argument brief in support of the New York Times motion to stay discovery, to suspend, to not hold discovery pending the appeal of the dismissal of their motion to appeal, and the interim stay pending the hearing on this particular motion. So basically you have the longer stay of discovery, which is pending the appeal of the dismissal of their motion, and then you have the sort of shorter, more temporary stay, which is the stay until they can adjudicate on their request for a stay.
Try to say that 5 times in a row.
Defendants seek a stay of discovery pending the Second Department's resolution of their appeal. Without a stay, defendants will be irreparably harmed, as the relief they are seeking under New York's anti-SLAPP law is intended to allow for quick resolution of SLAPP suits without the burden and expense of discovery. Proceeding with the exact type of discovery burdens the anti-SLAPP law is intended to prevent will obviate the very rights defendants' appeal seeks to vindicate, because even if the appeal is successful, the result will be the dismissal without benefit that the anti-SLAPP law was designed to provide, namely avoidance of the costs and burden of discovery. Now, I am not sure about this argument, but bear in mind I am a Quebec attorney with no particular expertise about the New York anti-SLAPP legislation, but it seems to me that irreparable harm, generally speaking in law, is recognized as being harm that cannot be compensated monetarily. So it seems to me that qualifying as irreparable, the mere fact that they might have to incur the costs of discovery, those costs by their very nature are not irreparable. But alas, what do I know? Let's just move on with this memorandum to get to the really juicy parts, which are coming up in about 30 seconds. The memorandum then goes over the background, which we don't really need to go over. I've done a couple of videos on it, but I will flash this screenshot so you can pause and read at your leisure, but then let's get into the really good stuff. Immediately after the video was released, it was widely criticized by numerous independent fact-checkers, news organizations, and reputable academics as being, among other things, quote, misleading, end quote, quote, unfounded, end quote, part of a, quote, disinformation campaign, end quote, and, quote, false, end quote. The New York Times, in continuing to reassert that the Project Veritas video itself was coordinated disinformation, alleges that the video was widely criticized immediately after publication. I, just for the fun of it, had to go to Google to put in the words Project Veritas, the nature of the video, and the very words that the New York Times is quoting here, just to see what the top search results would be. With the search terms Project Veritas ballot harvesting unfounded, the top result is the usatoday.com fact check, no proof of ballot fraud scheme. Fourth result, the New York Times article itself, Project Veritas video was, quote, coordinated disinformation. Put in the search terms Project Veritas ballot harvesting false, the top result, usatoday.com fact check, no proof of ballot fraud scheme. The fourth result, the New York Times article itself. Put in the search terms Project Veritas ballot harvesting disinformation campaign, the top result is the New York Times article itself, and the second result is the usatoday.com fact check, no proof of ballot fraud scheme. But wait, there's more. Let's just click on that USA Today fact check just to see who their sources were. USA Today fact check, no proof of alleged voter fraud scheme or connection to Rep. Ilhan Omar. Researchers claim video is part of, quote, coordinated disinformation campaign, end quote. On September 29, researchers at Stanford University and the University of Washington concluded that the video's rollout suggests it was part of a, quote, coordinated disinformation campaign, end quote. They write at the Election Integrity Project site. It's a great example of what a coordinated disinformation campaign looks like, preceding the ground and then simultaneously hitting from a bunch of different accounts at once, end quote. Alex Stamos, a researcher at the Stanford Internet Observatory, told the New York Times. And USA Today's source for this fact check?
The New York Times itself.
And by the way, go back and re-listen to what exactly Stamos said, because whatever Stamos said about the coordinated disinformation campaign is exactly what the New York Times did. They worked hand in hand with the EIP to simultaneously release their reports from two different angles to precede the ground, I believe, as they said, in order to get their story out there as a disinformation campaign.
It's a great example of what a coordinated disinformation campaign looks like, preceding the ground and then simultaneously hitting from a bunch of different accounts at once, end quote.
Whatever Stamos described as the alleged disinformation campaign of Project Veritas is exactly what the EIP did in conjunction with the New York Times, and now USA Today, in fact-checking all of this, is relying on the New York Times itself. All right, that actually was the biggest, juiciest, most salacious, hypocritical detail of this entire motion. Let's just get into the procedure, what happened, and what the New York Times arguments are. On March 18, 2021, the court issued the decision and order denying defendants' anti-SLAPP motion to dismiss. The court questioned the legislature's judgment in amending the anti-SLAPP law because it believed that the amendments, quote, have turned the original purpose of the anti-SLAPP law upside down, end quote, and, quote, granted protection to a Goliath against a David, end quote, but ultimately held that the anti-SLAPP law applied retroactively to the anti-SLAPP motion to dismiss. So the bottom line here, just to simplify some of this complicated procedure, the anti-SLAPP legislation had been amended after the lawsuit was filed, but before they had briefed their motion to dismiss, and there was a question as to whether or not the newly amended anti-SLAPP legislation would apply or the old legislation. According to the judge, the new legislation basically made it harder for the Davids to fight against the Goliaths. It basically reversed the protections of anti-SLAPP law, but that question ultimately became academic because the judge applied the newly amended anti-SLAPP legislation and still dismissed the New York Times motion to dismiss. More simply put, still, the judge applied the stricter of the laws as relates to the Project Veritas motion and still dismissed the New York Times motion to dismiss and allowed Project Veritas's claim to continue. The New York Times then gets into the criteria that it argues are applicable for a stay of discovery. CPLR section 5519C provides that, quote, the court from or to which an appeal is taken may stay all proceedings to enforce the order appealed from pending an appeal, end quote. Similarly, CPLR section 2201 provides that, quote, except where otherwise prescribed by law, the court in which an action is pending may grant a stay of proceedings in a proper case upon such terms as may be just, end quote. Under both provisions, courts have, quote, broad discretion to grant a stay, end quote, of discovery in actions pending the resolution of an appeal. Here, there are 4 broad and well-accepted considerations that justify a stay. 1. A stay is necessary to avoid prejudice to defendants and ensure that the appellate division can give meaningful appellate relief. 2. A stay will not prejudice plaintiff. 3. A stay is necessary to avoid wasting judicial resources and needlessly burdening all parties. And 4, the appeal has substantial merit and raises novel and important legal questions of first impression. We are not going to flesh out all 4 of those conditions as they are fleshed out in the memorandum. I just think that if they don't fail on all 4, they certainly are going to fail on 3 of the 4. In my humble opinion, a stay is not necessary in order for the appellate division to give meaningful appellate relief. If the appellate division dismisses the lawsuit, the defendants have gotten the relief they want. That is the dismissal of the lawsuit. It doesn't matter if depositions have been conducted. A stay will not prejudice the plaintiff. There is an expression that is as old as law itself. Justice delayed is justice denied. Justice delayed is itself a prejudice. But the more meaningful prejudice, having articles on the internet, having news pieces out there, fact checkers saying that you are coordinated disinformation is itself a prejudice. And the longer those articles stay out there in the ethernets of the interwebs, the greater that prejudice is for the plaintiff. And as far as the 4th condition is concerned, yeah, I guess maybe they have a novel question of law here because this is a newly amended piece of legislation, but that question of law is going to be as relevant whether they conduct depositions or not. This same rationale applies here. Denial of a stay here will prejudice defendants by effectively making it impossible for them to receive the full relief they seek on appeal under New York's anti-SLAPP law, namely dismissal without the substantial cost and burden of discovery. I am not sure about that, but I am well aware of the limitations of my own knowledge, but this next part really gets me thinking of something we say on this channel quite often. What is it?
Confession through projection, people.
Here, plaintiff will suffer no prejudice if a stay is entered. There is no evidence, for example, that is at risk of spoliation, no witnesses that are likely to be unavailable after appellate review, no claim that plaintiff is incurring ongoing damages, and should the Second Department affirm the order, discovery will proceed unaffected by the stay. Funny you should mention it, the New York Times, because before you did, I didn't even think of it, but now I am thoroughly convinced that there is, in fact, a risk of spoliation of evidence if this delays. I am thoroughly convinced that there will be witnesses that will be unavailable in the coming months if this delays, and thank you for planting that seed in my head. In protesting too much, the New York Times has in fact raised the best arguments as to why there should be no delays in this, because there will in fact be spoliation of evidence and witnesses will become magically unavailable. Denial of a stay would result in the waste of judicial resources and needlessly burden all parties. Life pro tip in the practice of law: when the opposing party purports to be acting in your best interest, they never are. They are always acting as a front for their own best interests. And then for the rest of the memorandum, they basically just proceed to rehash the arguments that they raised before the first judge that the first judge dismissed. Defendants respectfully submit that the court erred when it denied defendants' anti-SLAPP motion to dismiss. Specifically, the court erred by 1. Misapplying CPLR section 3211G and holding that, quote, the clear and convincing standard, end quote, for establishing actual malice, actual knowledge that the challenged statements were false, or awareness of their probably falsity, is not relevant when applying the anti-SLAPP statute, which, had the court properly applied the standard, would have been dispositive for defendant's defense given the lack of evidence submitted by plaintiff. 2. Construing the, quote, substantial basis in law, end quote, standard imposed by the anti-SLAPP statute as being, quote, below the standard for summary judgment, end quote, without imposing any heightened burden upon plaintiff in response to defendant's motion under 3211G. And 3. Misstating the law of defamation with respect to non-actionable statements of opinion by requiring defendants to expressly state that an item is opinion for it to be found to be one. The New York Times might be slightly guilty of strawmanning the judge's decision somewhat, but it's to be expected in these types of motions. Bottom line, the New York Times is just arguing the judge got it wrong, we need another judge to hear this to get it right, and in the interim we don't want to be deposed. Oh yeah, and we presented all of the required evidence to this judge. We don't know how the judge got it so wrong. The court also erred here because the challenged statements, when considered in context, are opinion. The term, quote, deceptive, end quote, for example, is not susceptible of being proven true or false in this specific politically charged context. You want to know what the very big problem is, the New York Times? You've already admitted in your defense that these were not intended to be opinion pieces. This is the legal version of sucking and blowing at the same time, and for anybody out there who has tried to do that, when you try to suck and blow at the same time, you end up choking. Moreover, the defendants presented significant evidence that the challenged statements were substantially true, including a report by the Election Integrity Project analyzing Project Veritas' video, the video itself, and other news reports about the video, all of which reached the same conclusions that the articles did about the video. Precisely because Project Veritas provided no evidence to support its contention that the video was substantially accurate, the lower court could not properly have held that Project Veritas met its burden under the anti-SLAPP law to demonstrate a basis for a jury to conclude that defendant's description of it was false. The judge already heard all of these arguments, and he concluded that there was enough in the file to proceed, and the New York Times is basically wanting to apply a judgment on the merits to a motion to dismiss. They want to apply the standards of a judgment on the merits at a stage where evidence has not yet been adduced. Conclusion: defendants respectfully request that this court enter an order staying discovery pursuant to CPLR section 2201 and 5519C until the second department decides defendant's appeal of the order, and enter an order for an interim stay of discovery pending resolution of this order to show cause, along with any other relief this court may deem just and proper. Now, the judge has already rendered an order not on the merits of this motion, but rather on the interim aspect of this motion, in that they have stayed the deposition pending an adjudication on this order to show cause. So they got the mini stay, they just haven't gotten the maxi stay yet. But part of me is in fact wondering whether or not the New York Times has basically waived any potential right they could have otherwise had to a stay of the proceedings by virtue of the fact that they filed their defense. If they were going to ask for a stay of the deposition, they should have done it before filing their defense. Or perhaps these are just the questions of a lawyer who doesn't know any better. But with that said, if you like my videos, you like my content, please be sure to like, share, subscribe, hit the notification bell, and drop a comment in the comment section below because it feeds the algorithm.
Eat the food. Eat the food!
To be continued. As soon as there are any developments in this file, I will do a follow-up vlog on it. Robert Barnes and I will be discussing it during our next live stream on Sunday, and I do think James O'Keefe is scheduled for a sidebar. Stay tuned for the big announcement, and if you want to follow Robert Barnes and I on Locals, you all know where to find us.
Oh, man, one of these days I'll get this right. There we go. Viva BarnesLaw.locals.com.
All of my content is also on Rumble, so you can watch us there. But more important than any of that, take care of yourselves, check in on friends and family, make sure everyone around you is doing well, and now you know your vlog. Peace out. Booyah!